So by mere construction. You say that, now you obviously have a position different from the Supreme Court's view. The right place to do this, obviously, is to go back to the Supreme Court. And you expect that to see in the Speaker's own case, because he's attached to this, to challenge
not
this
the Speaker, not the Speaker. The Attorney General has filed application for interpretation.
Yes.
It has brought into focus the real interpretive jurisdiction of the Supreme Court.
I make that point because the Speaker himself in Parliament, he's a defendant in the matter.
Yes, he's defending because he's asking for a certiorari, a question order of the Supreme Court order, which is illegal.
So you've seen...
It is a procedural error of illegality. What the Supreme Court did was the procedural error of illegality. So it should be struck out.
You've seen the Speaker's process.
What is important is the Attorney General's application, which calls for the proper exercise of the Supreme Court's jurisdiction. That's why I said the Supreme Court is now holding the hot potato.
You've seen the process filed by the Speaker?
I haven't seen it. I've heard it.
Okay. And you referenced the Attorney General, though. I've seen the statement of case he's put in. He is making the point that the Speaker got it wrong. And, of course, he's invited the Supreme Court to interpret it to mean that that expression of those three MPs in particular who had gone independent, it is for a future Parliament and not in this life. And so you cannot apply the vacancy to them.
How can you construe a futuristic application of a constitutional provision? It's absurd to say that the effect of the provision will be in the next Parliament. What is the relationship of the candidates to the next Parliament? It's not even determined. It's not determined by anybody except the electorate.